let me just say that I won't take too many minutes, but a little bit was said about my background. It's pretty easy for me to be interested in fair housing and non-discrimination law. I was born in 1947 in Bessemer, Alabama. I'm one of 10 children. We didn't have a lot, but my parents really worked hard to make sure we had opportunities. So when you talk about lack of fair housing, we also talk about lack of education opportunities, every kind of opportunity that you could imagine. And it was legal to discriminate. And I often say to people, when I was growing up and I was very young, that there was no job that any white person would want that I could have. So if they wanted it, they could have it. That's the kind of society that I grew up in. And so when you talk about fair housing, you talk about discrimination in housing and education and recreational facilities and libraries and everything, that's really the society I was born into and I lived in for a very long period of time. So it doesn't take much to get me interested in, excited about fighting discrimination. As they say, I am dedicated and have been all my life to eradicating it root and branch. And so that's my orientation. You also heard that I was involved in a number of public interest and other kinds of activities before I went on the bench, but fair housing was one area that I did some work in. And if you think about the 1900s and back to 1920s, when they first had zoning come into prominence in cities across the United States. First it was, to kind of protect housing from industrial facilities and those kinds of things. But pretty soon, the cities in the South kind of latched onto that as a way of segregating. And so they had zoning ordinances that said that blacks could only live in certain places, and that was to keep them from living in white communities. And that was struck down, as some of you know, in 1917 by Buchanan versus Worley, the Supreme Court case. Well, you know about restrictive covenants, and then that came into being. And that meant that the white citizens in the community agreed among themselves that we will not sell to black persons. And so that went on for a number of years. And you know that in 1948, that in Shelley versus Kramer, the Supreme Court said that a person who comes in, white person who comes into the state court to enforce those kind of restrictive covenants, that invokes state action on behalf of that court being involved. And so therefore, they found that that was a violation of the Equal Protection Clause. But remember, in that case, they said, if white people want to enforce these restrictive covenants between themselves, privately, and they want to obey the covenants they've entered into, that's okay. What's wrong is that you come into court, if someone has to come into court to enforce it. But that struck down restrictive covenants, at least from that standpoint. And then we come forward to 1967, the riots. There were tremendous riots across the country. And then 1968, Dr. Martin Luther King was killed. Now, there was always some rumination about passing a fair housing law, especially in light of the Kernan Commission report, which had been issued in February of 1968. That's after the riots. And that report said that we're moving toward two societies, one white and one black. But when Martin Luther King was killed, that was kind of the impetus to have the bill passed. And so it was passed, I think, 1 week after his death. So that's where we've come. But coming where we have in the area of fair housing is no different than coming where we have in the area of all the other areas of American society. It's almost inseparable. If you think about voting rights, and you think about the kinds of things that happened there, the grandfather clauses in the 1920s, which essentially said that white citizens who had grandfathers who were free were relieved of those onerous obligations they were putting on black citizens to become voters. And when that was stricken down, there was so-called white primary. And they said, well, what we're going to do is we're not going to make the primary system part of the state, but it'd be part of a private organization, and whites could therefore vote in that, and that would not be state action, and that was stricken down. and the poll taxes and all the other kinds of things. And so after there's one thing that's stricken down, there's always another. And so when you think about fair housing, it's no different than all of the other kinds of discrimination that have been rampant throughout society. And we know how we got our start. Very poor one at the beginning, willing to tolerate slavery, willing to have more than tolerate slavery, all that kind of thing. We didn't have rights for women, they could not vote, all those kinds of things. So we've had to kind of remake ourselves in the image of the Declaration. We've tried to remake ourselves because there was a lot to do. And so we've come a long way. Let me just read you, and it's going to be very quick, from a companion case to Shelley versus Kramer. And it's called, the case is called Hurd versus Hodge. It was a DC case that was decided as a companion case. And just to show you how intense racial discrimination is and has been, I'll read you from a deposition in that case. This is a person being deposed by someone at the NAACP. They say, question, now suppose, Ms. Hodge, it was a very, very light Negro, say 99% so-called white blood. Answer, it would still be a Negro, I think. Question, and it would not make any difference? Answer, no. Question, if you got a person in the block who was supposed to be white, and that person was undesirable in the sense of untidy or something like that, you couldn't do anything about it? No, certainly we couldn't. Question, and you would prefer that untidy white person to a Negro, no matter how educated or cultured? As long as they are white, I would prefer them. Question, no Negro, no matter how or whether he might be a senator or a congressman, it would not make any difference to you? Answer, it wouldn't make any difference. Even if the white man just came from jail, you would prefer him because he is white and I am white. So that's where we've come from. Kind of blatant discrimination, people who didn't have to hide discrimination, who felt they could be open about discrimination. This is where we've come from. And so with the Fair Housing Act, we certainly have come a long way in terms of having a law which allows us to attack blatant discrimination and to work toward getting rid of blatant discrimination. And we can do more with the Fair Housing Act, but I'm saying that's where we are. Now, those of you who are here will be on the program, will be talking about the important issues related to fair and equitable housing. And I'm not holding myself out as an expert, and I'm going to be sitting down. But it doesn't take much to realize that there are still lots of practices throughout our society that cause persons of color and other persons not to have equal and fair housing. High credit scores or down payment requirements that are not rational to their purpose. Disproportionately high risk loans to people of color. That's reflected in the great disparity of home ownership between blacks and whites. There are so many ways in which discrimination carries forward, and there are so many sophisticated ways in which this happens. I've looked at the program today. I think it appears to me to be a wonderful, comprehensive program. It's not a single shot, just how you go into court and fight housing discrimination where someone turns you down for getting a house. It's much more comprehensive than that. So it's my delight, it's my pleasure to be here as you think about how to continue to fight discrimination in housing. It's a part of discrimination generally in our society. Let's all eradicate it, root and branch. Thank you.